Well, welcome back, everybody. Here we are in the afternoon portion of the God knows what is going on with the Karen Reed hearing.
You are unmuted.
Auntie Bev has lost all credibility. She knows it. We know it. Let's see how she tries to scamper her way out of this one.
Why don't you go ahead and continue?
Thank you, Your Honor.
Welcome back, everybody. Good to see you all.
Please, the court. I first want to thank Your Honor for the generous amount of time you're according me.
Need to thank me. Just go right ahead, sir. And take your time, Mr. Alessi. I shouldn't have cut you off. I appreciate that, but take your time. This is important.
Thank you. So, Your Honor, I left off with page 58 of tab 8, which is last week's hearing. And what I want to do is to go to, because I'm going to go backwards ever so slightly because it's an important segue to returning to page 58. So I referenced the court to page 57, line 11, where the Commonwealth said, response, in quotes, "Hi, Alan. Subsequent to our conversation on Wednesday, the U.S. attorneys," and he's quoting purporting to quote the, and it's good to have, if Your Honor can be, having tab 1, which is the March 22nd email, because I'm going to compare and contrast tab 1 to where I am on page 57. And Your Honor, I'm sure will recall that I dubbed tab 1 the pause email.
Yes, so I have them, and rather than me going from tab to tab, I'm going to use my copies. So go right ahead.
Perfect. So I'll just refer to them, Your Honor, as the date. Is that what's best for the court?
Yes.
Okay. So the March 22nd email, I've dubbed the pause email.
Yes.
And because of obvious reasons, and it's got the word pause in there. And the pause is a very, very important concept because the pause is the stopping of communications before really things even got underway. It was before there was even an agreement, an engagement, et cetera, et cetera. So compare that, please, to the quote, purported quote on page 57. 11, "Hi, Alan, subsequent to our conversations," and he's quoting purportedly this email. "On Wednesday, the U.S. Attorney's Office asked me, are there any further conversations? Did we receive additional information from their office regarding how our involvement will move forward?" Your Honor, there's not one mention of the word pause in that quote. The word pause was left out of that quote. That is the foundation of that email. And it's not merely semantical, it's the cutting off of communications. And it's unfortunate that that pause was not quoted on page 57. Now back to page 60, or excuse me, back to page 58.
Yep.
And this is where I left off. Line 2, now this is an information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, TURI requests, and in assistance, the best I can to get as much information as I can. Defendant provided an outline of the questions and answers for direct examination. So this is where I left off. That's not correct. It was Dr. Wolf that provided the outline. It's really important when we're talking about a collaboration, et cetera, communications. That's not accurate. And Your Honor, what is important to note, Your Honor asked about when did the defense provide the discovery.
And you told me the 12th, right?
And I want to correct that. I was off by a day. It was February 13th.
Okay.
Because it's important to try, I clearly understand, to be as accurate as we can. I'm the one creating the standard that every word counts, every date counts, so I want to try as my best. I may get some things wrong, but I want to try my best to be accurate. So what I did during the break is I went and asked for the email that sent that request. So it's the email from the defense to the Commonwealth providing the discovery.
Okay.
And the email is dated February 13, 2015 from, and I've got extra copies if the court wants it, if the Commonwealth wants it, from Evelyn Arellano, and she is an employee of the Worksman Jackson firm. And it's important to who it's addressed to. 2, the first name on it is Hank. That's the first name on it. To Hank, Mary Ellen, Adam, and 9 more. Good afternoon. The Dropbox link below contains ARCA reciprocal discovery. Please let me know if you experience any issues accessing the files.
Okay. What time of day? Because if it's California time, it might be different than what we have here. But
It probably will be, but I don't know
Why
what
does it
time
matter?
of the day. I'm going to
Who
ask
cares?
the team if they can access what time of the day, because I don't know the answer to that as I stand here.
okay.
And
Go right
so-
ahead.
And so, but suffice it to say that the hearing was on the 18th. So it wasn't like it was a Friday and then we're back in court on a Monday. My best recollection, the calendar will be the best evidence, is that this was toward the middle of the week, right? But in any event, let's say worst case scenario was dispatched at 9 o'clock at night, California time, which would be midnight Eastern time. And let's assume worst case, it's therefore in effect the 14th. That's 4 days before the 18th that this is sent.
Thank you, News
Do you have a time?
Pardon me?
Do you have a time, Ms. Little?
For the 5 gifted
Yes,
subs.
1 moment.
Thank you.
Shout out
And
if
I'm
you got a
understanding
gifted
Your Honor
sub.
would like me to pause until you get
Just
to the
if we can, because I'm looking at a calendar. If you don't, I thought you may have had it. We can move on.
I believe it's approximately 6:30 in the evening. It was received by the Commonwealth.
Thank you.
And is that, may I ask Your Honor if that's Eastern time, 6:30?
Eastern Standard Time.
Thank you, Ms. McLaughlin.
And Your Honor, it was a Thursday.
I'm sorry.
It was a Thursday.
Okay, thank you.
So also, in big bold letters, at least on the printout, the subject is Karen Reed - ARCA reciprocal discovery. It's not like it was buried what was being sent. I mean, this was a lot of things, but it's right there, ARCA reciprocal discovery.
Was it just these pages that we've been talking about, or was it a lot more discovery?
May I confer with counsel? I think I know the answer.
It was just the pages, Your Honor.
Okay, thank you.
So it's not like ARCA is amidst a sea of other topics, right? This is the driving force of the email. And so, Your Honor, the question, and I'm going to keep moving on, but the question becomes, and I'm going to ask it more than once, but hopefully not too much, how is it that the Commonwealth on the 18th understood incorrectly, I think it's undisputed it's incorrect, that they got these materials from the federal government? We don't know the answer to that question, but I respectfully submit it's an important question. Was it an honest mistake? Was it just, as happens sometimes in lawyers working together, there's a lack of communication, there's a miscommunication? Is that the explanation? But I think truth and justice on these topics, since we're being so exacting and appropriately so, we should have an answer to that question. So we move on to page, so there we have on page 58, we have another incorrect statement. We have 2 of them right up off the top, and then we continue on to page 59. Your Honor, understandably, says the court. What is the date of that? Mr. Brennan. It's not dated.
When I said it, what was I talking about?
I believe, Your Honor, you were talking about the outline.
Just give me a second, let me make sure.
And Your Honor, if I may, I want to give you the second, but the basis for that answer is page 58, line 7, where the statement is, and what follows is all about the outline.
Okay?
So, Your Honor, appropriately and understandably says, what's the date of that? Here's the answer Your Honor got. It's not dated. It's not dated. Now, let's please just go back to tab. We're talking about the outline. Let's go back to the outline. And we can pick either one. I'll pick perhaps the most probative one. I'm not going to refer to the tab because Your Honor says you have these. This is the June 23rd email from Daniel Wolf. I'm just pausing to make sure you're... Thank you.
It's what I referred to as a script, right? That's what you're referring to?
That's what Your Honor has referred to it as.
Yeah, so that itself is not, I understand it's with the email, but it's not dated separately.
Well, Your Honor, I was going to get to that, but there's context for that.
Hey, go ahead.
The context, you're correct. The outline itself is not dated. However, the attachment, keep in mind, we produced these materials.
Okay.
So we deal in e-discovery all the time. And when you look at the attachments, everybody relies upon the attachment line, especially if it's a Word document. So it's wolf_direct.docx. So you know this email has an attachment. We fortunately have a file named direct. Your Honor has referred to it as a script. There is no other document that was produced that comes anywhere near close to this being the direct. So I don't believe there's any reasonable basis other than the other email on the quals that came the day before, 2 days before, the day before June 22nd, which has the same attachment wolfquals.dcx.
Can I ask you a question just because I don't understand? So what I have separately is the script and then something saying qualifying the expert. Is this all one document?
No, Your Honor.
So what is the date of the, so you're saying what I referred to as the script was sent on the 23rd?
That is correct, Your Honor.
What was the other one? When was that
The other one was
sent?
sent the day before on June 22nd.
Okay.
I'm just going to give it the name that the email has. I think it's wolf_quals document. Okay? So there's two emails. One's just the quals. The other, respectfully, Your Honor, I know what you're calling it. I'm just going to call it what it says.
Sure.
The title is direct. So it doesn't matter which one you're talking about. To me, it doesn't matter whether there's a date on the actual quals document or the direct document. We produced them in this fashion, and I believe the only reasonable conclusion is that the outline is what is sent under the June 23rd email. And Your Honor, the reason why I persist in this is because if Your Honor goes and looks at the, and this is important for the context, if you go back to the June 22nd email,
Okay.
the last sentence is, I will try to work on some direct examination questions tonight. So you know that when the direct comes in the next day, I think the only reasonable conclusion to make is that that direct outline was created after the 22nd or on the 22nd or after, and certainly by the 23rd. So that's what the Commonwealth had in terms of the information. So in conclusion on this point, but I think an important one, it's not dated, but here we go back to, Your Honor, the TURI request is a recent February response, but they, and I'm assuming the Commonwealth meant the federal government, send random documents. There's no real accounting. But there is an accounting on the face of the emails that
I'm going to ask you to hold that thought. I just have one other thought about
Yes,
this. So
please.
we're talking about Saturday, June 22nd, what was sent as an attachment with the email, and Sunday, June 23rd. So this was before the witnesses testified, right?
That's
And you're
correct.
saying that this was disclosed prior to the February 18th hearing. But was this disclosed prior to the witnesses' testimony?
The answer is no, Your Honor.
All right.
The
That, I
answer-
just wanted to be clear. That's how I see it. I just wanted to give you the opportunity to tell me if that's not accurate.
No, that's 100% accurate.
Okay.
And I'm going to get to that. To me, that's a Rule 14 issue, not a candor to the court issue.
Okay?
So now, if we could please go back to page 59.
I'm there.
Thank you. There's no real accounting. Now, I'm not saying that undermines the conclusions of ARCA. There's another okay, so to speak, with ARCA. Or I'm not saying they're not qualified witnesses, but it certainly shows some bias. I went over a lot less, but blah, 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 blah. Now, here's the next one. Another comment. He's quoting, would it be fair to say, because you had a lot of nighttime visibility work, your cases frequently involve pedestrians? Now, and then yes, unfortunately, there is a direct correlation between the time of day and pedestrian facilities. Statistically speaking, most pedestrian facilities occur during the evening.
Fatalities.
I'm sorry, thank you. Fatalities occur during the evening and night hours. End of quote. And then the Commonwealth adds a commentary. That would have been nice to have. They had it. They had that. What's the objective evidence that they had it? I go back to the voir dire. They had it 4 months ago. 4 months before last Tuesday. They had it before we turned over the discovery. And what's the objective evidence that they had it? Is the voir dire of June 18, 2024 of Dr. Wolf that I referred to earlier, page 167, line 12. This is Dr. Wolf. Well, to give you an example of that, so I do a lot of nighttime visibility work where, for instance, let's say a pedestrian is coming down to the roadway, etc., etc. But that's not the end of it. They had it twice. So if we go to the direct testimony of Dr. Wolf that I referenced earlier, this is my tab 6, but I'm going to stick with, it's the date of June 24, 2024 of Dr. Wolf. Page 36-65.
Okay?
Line 22. This is Dr. Wolf's answer. Several hundred, period. As I mentioned earlier, you know a great deal of my work is in the field of lighting and visibility. Here comes the key points. So there is a direct correlation between time of day and pedestrian incidents. We see a rise in the evening and night hours just due to drivers having a difficult ability to try to perceive and recognize individuals. So I certainly see a lot of pedestrian collisions in my casework. There it is.
I did see that.
So let's go back. That's misstatement number 5. It would have been nice to have, I agree. It would have been, and you did. Twice. Next. Reading on the same page 16, he's quoting. So, my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. That's the end of the quote, and then the Commonwealth takes on with a commentary. Pretty important stuff in this case. I agree, and you had it twice. And then he comments, if you don't want me to say this, that's fine, that's fine. Then the commentary from the Commonwealth. Shh. And I went back and watched the video. Shh. Don't tell them. I'm sorry? What do you mean don't tell them? You were told twice in the voir dire And in the direct, it was just unvarnished. And here's the important part, Your Honor, another important part. Mr. Jackson drew that out on direct. Not only was he not shushing or hiding, it was Mr. Jackson's question that drew that out. So here you have Dr. Wolf trying to figure out, is this something that we should say? We're not. And honorably, Mr. Jackson, nope, we're going to hit it head on. Mr. Jackson draws it out, puts it right on the table. 4 months before February 18th, and the whole world heard it live. Next, if you could, Your Honor, please go to page 60. I'm sorry, there's another point at the no, let's go, if we could. I don't want to take the lesser significant ones. I want to focus, because there's many of them. I want to get to the more significant ones. So then we have on page 60, line 2, and then a bill from ARCA to the defense for $23,925. That's not a trial by ambush. That's getting duped. So I, Attorney Brennan, didn't know any of this. But I've tried a few cases. I've been around the federal court a bit. I know how it works. So what is the import of that statement? I didn't know any of this until I got it from the federal government. And we're talking about the invoice. No. You know about it because the defense, after the certificate of completion of discovery, and 6 weeks before the trial is starting, the defense affirmatively turns it over and does it not buried amongst several discovery documents, but essentially a tailored discovery response that's titled Karen Reed ARCA Reciprocal Discovery.
Oh.
That's not a very good way to try to cover up something.
Yeah. Yeah.
There is no statement about the date of the invoice on February the 18th. So people are left to wonder, when did it occur? When was this bill stated? The date's important for that invoice. Then there's a lot of statements made. Sometimes parties pick sides, agree, blah, 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 blah. And then it allows the ability of one side to use ghosts. They create illusions and shields and say something's there and something's happening, a federal investigation, and this person, and then this happens. Your Honor, I think it's important for the defense to be allowed to speak to the very words that were used against us. Ghosts, illusions, shields. That's what we're accused of. I choose to try to comport myself and practice a certain way and give people a little bit of the benefit of the doubt. But if we're going to be talking about ghosts, illusions, and shields, I don't think it's the defense that's creating ghosts, illusions, and shields here.
Bam!
The illusion,
Bam!
and it's more than illusion, it's a statement of fact, is that all these documents came from the federal government.
Yes.
It's not an illusion. It's a statement of fact. Statement about federal investigations that were these are not ghosts. We're not creating it, but I'm not going to go any further on that topic. But the ghost word was used to, in my view, the way I read it was, these topics we're making up, right? And we're hiding things, shield, right? We're shield, I interpret it as, you're preventing us from getting this information, defense.
When it was
and this
given
is 5
to
days
you.
after we had provided it.
Yes.
Next line. Page 60, line 13. I don't care if the ARCA witnesses testify at trial. I'm very pleased to hear that. I don't care about their opinions. I'm pleased to hear that too. But I care that it's unfair, imbalanced, and hidden. Hidden. And that is based upon the faulty premise that we didn't turn it over and the Commonwealth got it from the government. There's no other way to read it. And the Commonwealth, like the defense, is entitled to discovery. I agree with that. The Commonwealth is entitled to discovery, and you got it 5 days before February 18th. Now comes to the court. all right, I'm going to take a recess. And I certainly, Your Honor, am not going to be so officious as to even delve into why Your Honor wanted to take a recess. But I will tell you what I thought and what I believe occurred. Your Honor listened to a completely counterfactual rendition of some of the most important issues of the day and, frankly, of the moment in this trial. And the reason I've got a little bit of an inkling is because what happened when the court came back. So what I concluded, after all of this and the court staying a break is, after all of these inaccuracies and piling on of inaccuracy after inaccuracy, there's a cause and effect in my mind between the several and serial inaccuracies, the break right in the middle, and then the court comes back. And I understand, I don't really, and I'm going to get to this, see the justice in terms of this presentation to the facts. And that's what we're going to be talking about, facts and representation. So here's what the court says. After hearing all of this, and I want to underscore something, Your Honor, and I'm not going to get too lofty with due process and notice, but it's important to hit some of these points. All of these topics that were raised were not in a motion. They were not in an affidavit. And I've had this issue before with other motions under what's required in an affidavit.
In this case? Or are you just saying generally you've had this issue in other cases, or do you mean this case?
Other cases, Your Honor. With there not being an affidavit, right, where someone's got to be very, very careful about what they say. But in this information that Your Honor had to be subjected to was not in anything that we had notice of, these topics. We had no notice that this was coming. There was no affidavit that someone had to swear to that all of these facts were correct. And Your Honor takes the break. So we didn't get an opportunity to stand up and say, what I'm being given the very fulsome opportunity to say today. So Your Honor comes back. All right. So the Commonwealth just provided the court with information. And I don't even want to repeat these words because it almost pounds on to the prejudice to the defendant. But Your Honor well knows what Your Honor said. But it certainly had the words in there that were very, very difficult on the defense. And you say, so for that reason, right? So the Commonwealth just provided the court with information that causes me, and then it goes on. So it's clear that Your Honor was relying upon that information, which was only given verbally, right? And you say, so for that reason, I'm going to suspend today so that we meet again, and then the rest, so be back in here. Mm-hmm. Unfortunately, that's not the end of the prejudice.
Oh.
So what happens is, all of a sudden, and Your Honor basically said, and this is all so key.
Get her,
so you
man.
said, I'll see you in a week from today.
Get her.
And then Your Honor continued on page 61, line 12. And where Mr. Brennan, where the federal authorities have been kind enough in the past to allow me to have copies of everything, would you be kind enough to call over there, check with whomever you were dealing with, so to see if I can, in fact, get a copy of everything that you just read? It was only then when the the reality hits that you're looking for the backup for what's being said. Up to this point, Your Honor's understanding, all of this came from the feds and the defendant didn't turn it over. So what does the Commonwealth do then? Does the Commonwealth stand up and say, whoa, wait a minute, I've made a mistake. And Lord knows I've made mistakes before. They didn't stand up and say, a very significant mistake, my whole predicate for my whole presentation was, I have to even fight the feds to get this information. Lo and behold, I got it, and I've been duped, and I've been ambushed. Rather than saying that, and you know what, I don't even know if I would have had the courage to say it in open court, I might have asked for a sidebar and come up and said, Your Honor, my bad. You know, this is that. But that didn't happen.
No.
So what did happen? The Commonwealth says I can, and there's a brief chronology I think Your Honor should be aware of. So the defense is still not able to get up, but the Commonwealth is continuing on. If I could add that right now, it will take me less than a minute. The court, okay. So the Commonwealth goes on, says the chronology is December 4th. We sent another TUI request, 2024. January 6th, we filed our notice of intention to exclude ARCA experts. January 30, 2025, the United States Attorney's Office sent a response to both ours and the defense request. Without any prompting, on February 6, 2025, the defense and the prosecution received an email from the U.S. Attorney's Office saying that the contract had ended with the ARCA experts and that if either party wanted to engage, the original materials are still protected. This was a change in position about whether the party could be impeached. On February 11, we filed a motion to exclude. February 13, the defense provided us the emails that I read. Buried in a chronology is, and in the middle of a sentence is, the defense provided us with the emails. I think I said, I'm going to repeat that. I think I said the federal government, it was the defense. February 13th, they sent us the emails and the direct examination outline. I think I said that was the whole basis for the entire presentation, was that the Commonwealth had to fight even the feds to get them. And then it goes on. We reached out to the federal government, but you know what was not said in lines 9 through 14? What was not corrected? It wasn't corrected that the invoice came from the defense. Just the emails.
I thought it meant everything, but
I don't understand how that conclusion could be drawn, Your Honor. It didn't say the defense provided us with all of the entire production. The defense provided us the emails that I read. There was no email.
I think Bev is folding.
The invoice was discussed as a separate item, and I can go back to it. When the Commonwealth was talking about it, they never connected it to the emails. So then we reached
it was because I received a copy of it.
Oh my God.
I think it's because I received a copy of everything that had been referenced.
Yes, but I'm going to get to the point about the importance of correcting misstatements, because 3.3A1, everybody focuses on the first sentence, which is, thou shalt not make a false statement of fact to a court. The second part of 3.3A1 is you get the opportunity to correct. You got to correct a material, and I've got it in front of me, but I'm just paraphrasing. I want to get to precisely. But that's why I perseverate this on this, Your Honor, because I trust that the court's going to hold everybody to the same standard. And so I think there is a proper inquiry. I don't intend to be officious as to what the court should do, but if we're going to start looking at comments of defense counsel, I believe we have to look at all comments. And again, I'm going to go back to my own view is this. Being a lawyer in cases like this is hard. Being a judge in cases like this is hard. Mistakes are going to be made. So we go on into page 62, line 15. We reached out to the federal government again because I was curious about the change in position on February 6th, that the contract was ended but that parties could contact ARCA. Obviously, the Commonwealth is in no position to contact ARCA because that would naturally preclude the defense from retaining them. So we refrained and we will not reach out to them. This is really an interesting statement because you read it, because that would naturally preclude the defense from retaining them, yet at the same time the Commonwealth, for the fourth time, has moved to strike our ability to use ARCA. So then the court goes on, all right, so the information that was provided to you, not from the federal government, so Your Honor knew at that point, I don't believe Your Honor had any basis before that to believe that it had come from the defense. I'd like a copy of it before you leave the courthouse. So I hearken back, Your Honor, to what I conclude drove Your Honor to make those impactful statements about, on the top of page 61 was the presentation of the Commonwealth that I counted had 10 misstatements.
Oh
10.
my
Before
God.
Your Honor caused the pause.
Wow.
So, coming to what happened then. The Commonwealth, having not giving us notice that this was coming, these topics, not putting any of these statements in an affidavit, we didn't have the ability to stand up. But I will tell you this, Your Honor, I greatly appreciated the week that we got, because I do believe that Your Honor intended that counsel be given, defense counsel and defense, a fair opportunity to go look at this. And that's the way I'll speak for myself. That's the way I took it, and I appreciated that, because that's allowed me to go spend the time that I spent to try to do my level best to give the court an accurate rendition of the fact, because as an officer of the court, I believe that is a sacrosanct duty. And in a matter where the very issue is, what are counsel saying to the court and is inaccurate, I wanted to make sure I could do the best I can. Now, I may have made a mistake here or there, but I just want, and today, but I want to make sure that I recognize Your Honors giving us of that week, and we've tried to take the best opportunity for it. So what happens? What happens after these 10 misdirections? The court's comments go viral.
Yeah.
And I'm not saying this for drama's
He just brought
sake.
the internet to the
I'm saying
courtroom.
this for what has impacted the defense 6 weeks before trial starts, while jury notices are out in the mail. Those words, based upon the misdirections that your court had to endure, have gone through, and I'll just name a few headlines in the Globe, the Herald, every TV outlet, social media exploded. And these are not trivial issues. And more than that, the veracity of counsel has been called into question. There's commentary of everybody about what's going to happen to certain members of the counsel's team, and whether it's intended or collateral damage. We've got the ARCA experts, which are key parts of our case. Their credibility is being pillared throughout the public domain. And
I can't watch.
this could have been avoided had there been an accurate recitation of what had occurred. And Your Honor, I don't know if this can be remedied. But it surely shouldn't have been
Hey, Nick.
exacerbated.
Oh my God.
I would now like to move rather, hopefully, efficiently through the next step, which is to point to the Massachusetts rule and give the court my view, and I have to reference because you're...
Again, you don't have to tell me what you're going to do, Mr. Lessie. Just go ahead and
I'll just
do
go
it.
ahead and do it. My apologies.
He's just giving you
So now let's just turn
a chapter.
to...
Like, relax, lady. He's actually trying to help you. Pay attention. He's trying to help you make your job easier. I love Jackson's new beard, by the way.
Model Rule 3.3A1.
Look at Yannetti. Yannetti is
This
so angry.
applies to every counsel in this room, of course.
I would be too.
A lawyer shall not knowingly, so there's the adverb of the mens rea, knowingly, make a false statement of fact or law to a tribunal.
Obviously. Oh my
Or
God, the zinger! The
Fail
zinger!
to correct a false statement of material fact or law
Oh.
previously made to the tribunal by the lawyer. So we all know the mens rea of knowingly. I don't, and this court knows it
No
better than
way.
everybody,
He's going
so
for
I
the
don't have
gullet.
to get into that. But in terms of make a false statement of fact or law to a tribunal, I don't see that on behalf of the defense, and I'm going to get to the new item of February 6th, because we haven't covered that. Your Honor brought that up today. But certainly with regard to the representations that I've gone through and the statements that were made, especially on June 10th, they were 100% true and accurate at that time. They were 100% true and accurate, and that's why I went through the notebook. Or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. And there's no real time period that's given for the attorney. But here is something very important, Your Honor, and I'm going to parse the grammar because it's what you do in construing the statute. It says, or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. So the is a definite article. So it's like an adjective, it's a definite article. Lawyer is the noun. The lawyer refers to the lawyer who is perhaps made a false statement of fact or law to a tribunal. So it's sort of like you make a misstatement, it happens, but you got to correct them, right? And what they talk about is, what do you have to correct? You have to correct a false statement, so it has to be false. It has to be knowingly false, of material fact or law.
Yes.
And material has been interpreted in the context of 3.3A1 to be a statement of fact or law that caused a court or adjudicator to have relied upon it for a determination. Essentially what the case law talks about, that it's influenced the judge's decision. So let's go back and even let's assume hypothetically that on June 10th there were misstatements made. It's not any misstatement. It has to be a failure to correct a material. You have to do it knowingly, and then you have to fail to correct a false statement of material fact. And in terms of what Your Honor had, it's the same lawyer that we're talking about in both clauses. And that is why I spoke about Mr. Yanetti's statements on the 10th, about what he knew, the fact that Mr. Jackson was handling the ARCA experts. So it's important to be analyzing what lawyer is saying what and which lawyer is to be making correct to correct the statements. So I go to the analysis with regard to 3.3A1, and as I said, I'm keeping separate 3.3A1 from Rule 14 because they're different analyses, as the court knows. But I want to hit the one of the most important ones first. So there's not a false statement of fact or law to the tribunal, and I will stand here as long as Your Honor needs if Your Honor feels differently based upon what I've said. Or fail to correct a false statement of material fact. So what I'd like to do, Your Honor, is now go to what Your Honor brought up today, because I was prepared for the June 10th. I wasn't prepared for the February 6th.
Do you need time to that?
I don't. I have taken the time. I appreciate the offer. But I would like to draw your attention, Your Honor, because
He's trembling.
I provided context on June
He's
10th,
going for it.
I think context for February 6th is important. And so what I'd like to do is to go back earlier than what Your Honor quoted this morning, because I think the context is important.
Right, so I have that entire transcript, like I said. What page are you at?
I am starting on page 40.
Okay.
I start with line 1.
Oh boy.
Mr. Brennan, correct. I had a conversation with one of the two prosecutors I spoke to, and the only means of trying to obtain information they suggested was through a TUI request. I don't think it's the Commonwealth's obligation to seek discovery, part of Rule 14, but I wanted to assist the best I could, so I made an assented to request, and they responded with a letter. I think you received a copy of it. Do you mind if I share it with, no, okay, I received it, I sent a 2-way response, essentially rejecting all of my requests on multiple grounds. So to be fair to the Commonwealth, Your Honor, this is February 6th, and they haven't gotten our discovery, right? They're just still trying to get it from the government. They don't have it from us yet. The court, all right, can I get a copy of this? If not, I just need, and then Ms. Bugalton, you can retain that copy. Thank you. So I'm not going to stay here and read it right now, but all right, Mr. Brennan, of course. And so inevitably, I'm not making any motion right now, but I appreciate that as the proponent of the evidence, defense's obligation to give Rule 14 discovery. I do not think, even despite their testimony, they've complied with Rule 14. And so the reason I forecast this was because I appreciate the April 1st trial date. If the defense, through no fault of their own, is unable to comply with the discovery, I think that we're entitled under Rule 14. I will at that point move to preclude the witnesses. So I think the important in this snapshot in time is all of the discussion that occurred on February 18th, and I'm going to underscore this. That presentation was not about the substance of what was in the email. The Commonwealth never had an issue with that. It was all about they had to get it from the federal government, and we didn't turn it over. Your Honor obviously has read the February 18th transcript. You can draw your own conclusions. But on February 18th, they were not on the issue of anything other than they thought that they didn't get the material from us. So now we continue on. The court. Move to exclude the witnesses? Mr. Brennan, yes. The court. What do you say, Mr. Jackson? Mr. Jackson, I don't want the witnesses excluded. What do you want me to say? The court. I asked you all to try and work out something. The original protective order permitted that we can do in court anything that would rule. I expect you to say something a little more than that because, and Mr. Jackson, well, I'll wait to get this motion. The court, all right. Last time, Mr. Jackson, let me put it this way. The court, hold on a second. Last time we did voir dire of these witnesses, it seemed to me that that was the logical conclusion. I'd be able to get both sides' discovery. We did that. That seems like a logical alternative to the exclusion, right? Your Honor knows what you're doing here. I guess we can wait and see if I exclude it on a motion to exclude. It just makes sense to me to set that up now rather than waiting. I don't know when they do that, when the Commonwealth, based on their witness list, recalls them, is that when you want to exclude it. So I sort of expected the defense would have some suggestion. If you don't, you don't. Mr. Jackson, and this is the key context. I can tell you this, the Commonwealth has exactly, this is an interesting and sort of different set of witnesses. The Commonwealth is saying that pursuant to Rule 14 and, exclusion and preclusion of a witness is a punitive sanction for Rule 14 violations. Ms. Reed has not violated anything. Why should she be penalized when the Commonwealth has the exact same batch of information that we have about these witnesses? And there's more context to that. I understand the import of these words so far. So I don't have any more information. I don't have any additional discovery. I didn't hire them. I didn't ask them to engage in additional protocols. So I've got nothing else to give to Mr. Brennan. He's got the same information I got and he got at the same time. What Mr. Jackson is referring to here is the disclosures from the U.S. government, not the disclosures that were going to occur on February 12th and 13th when we would get the certificate. We had the certificate of completion of discovery. We had 30 days, technically, to turn it over, but it got turned over on the 12th. So then it continues on, is important. The court, if I don't exclude it, would other side be seeking a voir dire? We would not seek a voir dire because they're eminently qualified and there's no other discovery to give. They've provided. The federal authorities provided all the discovery that was attended to their analysis and testimony. So what we have in terms, Your Honor, this is important, and I'm going to go right back to 3.3a. We have Ms. Little handling all the discovery. Mr. Jackson is not sorting through discovery, knowing what we got, not recalling what is in the possession from March 22nd, not recalling all of those items. That was Ms. Little's responsibility. So what happens? What happens is Ms. Little handles the production, goes back and does the diligence that she always does, takes all that material, sends it over to the Commonwealth. On February 18th, the defense did not have the opportunity to address the issues that Mr. Brennan had brought up. But I now want to go to the statute and why it is important, because the whole issue of discovery, the whole issue of batches of information was provided. And it was provided before, well before the 18th, before any of these issues came up. And Your Honor, respectfully, whatever the court may consider to have been an inaccurate statement, there is no knowing misstatement of fact. Mr. Jackson has never, I can tell you this from personal experience, I don't see him ever touch one item of discovery in terms of here's what we're going to collect, here's what we're going to turn over. Never have I seen it happen. I've spoken with him, he can speak for himself. That's not, so there's, even if you take any reading of February 6th, Mr. Jackson is focusing on and thinking the discovery is just what everybody has from the federal government. You've heard this many times. We can't produce more than the feds have, but we certainly, and I want to hit this head on, we certainly had those March 22nd, March 22nd, we had those emails at the time that statement was made. We had those. We had the direct, we had the quals, not running away from that. But the question is, at the time Mr. Jackson made those statements, he's focusing on the government, and he's not knowingly saying in his mind, oh, well, I know we've got these emails from way back when, and so with regard to the shall not knowingly, there's no evidence of knowingly here, and I don't believe, respectfully, there can be an inference stated. When I've looked at every single case where the court can look at the circumstances, so knowingly is not merely a subjective question of what an attorney has. The court is entitled to look at the circumstances and, as the case law says, should make an objective determination on knowingly. But the cases, and I can give them to Your Honor, the cases are legion, that the court cannot draw an inference from no fact to conclude it was knowing. They got to have some basis, and I'll give you some examples. What happens is if, let's say somebody, one of the leading cases is, unfortunately, a woman attorney was in a bad divorce. She had financial statements, and she made misstatements of fact about her financial statements. And then the question became, did she knowingly know it? And what the court did is she said, no, I didn't know it, I didn't remember it, I was under psychological stress. And what the court did was they went and they looked at the circumstances and saw emails and conversations she had with her accountant, where she clearly knew about those statements, and she told the court she didn't. So there's an example of you've got to have circumstances that the court cannot just jump from a lawyer said this to it's knowingly without some basis. That's why the mens rea is there. So in turn, and that's the only, the February 6th, respectfully, that's the only aspect, and I went through all the others, that even comes close to a false statement of fact by Mr. Yannetti or Mr. Jackson. In sum, Mr. Yannetti's statements on June 10th, all completely accurate. All completely accurate. Mr. Jackson's eliciting of the direct testimony at trial, when he asked, have I ever asked you specific, questions, etc., that's completely true because it was Dr. Wolf who sent the questions in. So we now are left with February 6th, and I've given you that construction of the statute. My last point, Your Honor, is going to go to the Rule 14 which is, and I'm going to spend a very short amount of time on this. Now that the Commonwealth knows that the discovery came from the defense, I want to go back to, please, the February 18th transcript, because I want to keep separate analytically the ARCA from defense counsel, because obviously for Ms. Reed is obviously very concerned about her defense counsel and her choice of counsel, which is going to be my last legal point. But in terms of what occurred, I want to go to and quote the Commonwealth on the transcript. I am on page 62, line 18. Obviously, and by the way, this is toward the very end of the 18. Obviously, the Commonwealth is in no position to contact, et cetera, et cetera. And what does that relate to? If Your Honor would go back to page 60, line 13. And it's a repeat, but I didn't get to the point here. I don't care if the ARCA witnesses testify at trial. I don't care about their opinions. But I care that it's unfair, imbalanced, and hidden, and the Commonwealth, like the defense, is entitled to discovery. Key line. So, if they can produce the discovery, I'd welcome ARCA. I want to repeat that.
You don't need to repeat it.
Okay, so my point is, we produced the discovery. Why is there still an issue with ARCA? These aren't my words. So I want to cover, before I get to the Sixth Amendment issues, the point that ARCA should be allowed to testify. We've complied with our Rule 14 obligations. There's no prejudice. They have the discovery. They've obviously had from the government a long time everything about ARCA. So I want to touch that base to make sure that either intended or collateral damage, that ARCA still gets to testify, because it's a key part of the defense here. Now to the Sixth Amendment. The United States Supreme Court has held repeatedly that a defendant's Sixth Amendment right to defense counsel of their choice is a root basis of the Sixth Amendment. Is it an absolute right? No, Your Honor. If counsel does something so egregious, doesn't correct it, the Sixth Amendment gives way to the need for the court to have candor, the need for the court to have decorum in the courtroom. So I understand that. My presentation today was as an advocate, of course, foremost, but also to provide all the information. So when Your Honor balances that sacrosanct Sixth Amendment right with whether or not there has been such a level of conduct that can be diluted or trumped. And I give Your Honor United States versus Gonzalez-Lopez, 548 U.S. 140, 2006. And in that case, there was violations of the local rule. And the court, and the court struck their counsel for that, and the
Is that counsel pro hoc vice, or was that not?
I'm going to get to that. The answer is the counsel. I want to be sure of my answer. Yes, and I'm going to read my conclusion because it doesn't say pro hoc vice, but I'm going to read you a part of it that says, during the hearing, however, the magistrate judge revoked Lowe's, that's the attorney, provisional acceptance. So I believe that's the parlance of pro hoc vice, but Your Honor, I'm pretty sure, but I'm not 100% sure. And then the following week, et cetera, and then the revocation occurred. And yes, it was. So the Supreme Court holding, government conceded that Gonzalez's Sixth Amendment right was violated below where the court denied pro hoc vice admission based on perceived violations of a local court rule.
All right, so pro hoc vice was not permitted in. It wasn't a revocation of pro hoc vice. There's a difference,
There is
obviously.
a difference, and both occurred in this case.
Okay.
There was both. Good point, both.
He's trying to get Brennan off the case.
Your Honor,
Holy mother of God. This is incredible.
and there are other cases when you have the Sixth Amendment, the fact that someone is pro hoc vice status is not the determining factor. The Sixth Amendment, in terms of legal dignity, is way up here, and then the pro hoc and the local rules are down here. It's only when the violations that undergird the pro hoc vice get repetitive, get more than repetitive, but go to things that are done that aren't corrected. And the issues that I've seen in my research, Your Honor, is that they have to be so, the violations have to drive so much to the core issues in the case. It's like suborning perjury, putting people on the stand when they know they're wrong, literally having objective evidence that counsel had a document in their hands, almost literally at the same time they're telling the court they don't have it. It has to be that severity to trump the Sixth Amendment. And why is that, Your Honor? Because the court has alternative remedies for if they really think that is happening. And that is going to be my last point on the Sixth Amendment. The case law is replete with the trial court having to be careful that whatever they do, even if they believe there's a basis for some sanctions, that the court look to do them post-trial so that there is not for the trial the bleeding in of those issues into pretrial matters. And the case law, there's a mention of that all the time. It encourages the trial courts to make sure that they're very, very sensitive to that issue. I don't think the courts are being all that sensitive and empathetic to the lawyers, but I think what they're doing is appropriately trying to make sure the defendant gets a fair trial, right? And the defendant is not adversely affected by whatever the counsel may or may not have done. But I want to be very careful and clear, Your Honor. I'm not saying that is sort of like mitigation. I'm saying, importantly, the time I spent that there was not these violations. If any occurred, they were corrected. And on Rule 14, there's no prejudice. And therefore, I conclude, Your Honor, and I would urge the court.
Here it is.
What happened on February 18th? There were some misstatements, and they weren't cured. I don't want this to turn into, and I'm not making this argument, I'm not making an equivalence argument. I'm not saying, okay, now let's turn to the Commonwealth. To the contrary, Your Honor, and I hope I've provided a factual and legal basis. I don't want any of this to continue. I don't want scrutiny of the Commonwealth statements on February 18th unless there's going to be continued scrutiny of the defense counsel. And I don't say it as a camouflage or a shield. We've got a lot to do between now and April 1st. The last thing I'm sure the court wants or anybody wants is to have something happen where that date can't be met because of whatever actions come out of this. My hope is that we all understand we make mistakes. Mistakes have been made clearly by both parties. And I would urge that the parties, not talking about the court, the parties take a breath, a deep breath, and focus on the matters that are important, which is how can we prepare to make sure that the presentations to the jury are candid, truthful, and most importantly, effective so that jury can make the best decision.
Wow.
There's a lot at stake here.
What a mensch.
The issues are momentous, And that is the focus of the defense. And I, again, conclude, but I would ask that I have, if anything said, that Your Honor has any concerns, I would really appreciate hearing them so I can take them on. Mr. Jackson, Mr. Urnetti, any questions Your Honor has, I would greatly appreciate it, my presentation notwithstanding. If there's still concerns with the court, we will take them on as best we can, and certainly candidly.
He's not
Thank
even
you.
asking to
All right, I
remove
appreciate
Brennan.
that. Before I give the
Wow.
Commonwealth an opportunity to respond, I need 10 minutes.
Oh, wow. Oh, my God. This is unbelievable stuff. This is some of the most stellar lawyer work I think I have ever had the pleasure of witnessing in my entire ever-living career. This man, after literally pounding the law, the duty of candor to a tribunal, when he said those words, and he pointed to the rule, and he said, basically, in layman's terms, in simple terms, let me explain. He said, Brennan lied to you openly. Not only did he do it openly in your courtroom, he did it 10 times over. He misled you. He made you believe, sir. This is why Judge, I can't call her Judge, sorry. This is why Auntie Bev was so shook up. Because she received a bunch of deceptive statements from Brennan last week. And I'm not privy to that hearing. I was still sick with the flu, so I do apologize. I'll probably have to catch myself up on that hearing and exactly what I remember. Earlier today, this morning, I said misstatements. I want to correct that. Apparently, Brennan did not have. There were intentional lies. Let's call them what they are. I know that Alessi does not want to call them lies in open court. But he called them lies. That's what he said. Brennan lied to you 10 times over. And rather than, and this is why I called him a mensch, rather than saying, look, how about we remove this guy? He's like, no. Let him stay on. But I want to make sure that the court is aware of the deceptions that were put before you. They failed to correct them. They failed to address them. They went viral. The media is now involved. The jury pool is being tainted. But despite all of that, he says, let's continue moving forward. Let's continue moving forward. What a guy. I am stunned. I am absolutely stunned. This is I can't even find the words. This kind of lawyer work doesn't exist anymore. I thought it was extinct. I thought it died like 100 years ago, maybe 50 years ago. But here we are in 2025. Wow. It makes a lawyer want to weep. I'm not kidding. I almost have tears in my eyes. How impressed I am. That was spectacular. So now, Auntie Bev took a 10-minute break, which is fine. I know you guys have some thoughts on it, I'm sure, and so do I. I'm not going to say them. I'm almost a little empowered by Alessi. I feel so like he kind of rubs off on you a little bit, you know? Like that's all right. Let me come back. So now Auntie Bev needs to go in the back, take 10 minutes to decide. Well, she can't decide what she's going to do yet. She's going to give Brennan an opportunity to speak. Brennan is conferring with Lally right now. I wonder what those 10 misstatements were. I would really like to know what those 10 misstatements of fact were last week, so that hopefully we can have a good and fair trial. I was going to say next month. It almost feels like it's about a month away. Jeez Louise. Okay, so I'm very curious. I'm very curious what the government is going to say. What is Brennan going to get up there and say? What I did not have. Obviously, he's got to get up there and say I did not misspeak. I did not misstate the facts. I did not violate my duty of candor before the tribunal. We know all of those are coming. Obviously, he's not going to admit in open court. Yeah, I lied to you. My bad. Oopsie daisy. Slap on the wrist. Let's move forward. Notice how he had the opportunity to cite probably 20 cases throughout his presentation. And his presentation took, not including the lunch hour, his presentation took like 3 hours, just slightly over 3 hours. And when you really think about it, he had an opportunity to quote so many cases, but he didn't. He only quoted one case, the most important case, Gonzalez, a pro hac vici attorney who had his pro hac vici status revoked because of their failure to be truthful, honest before the court, before the judge. And despite the one case he quoted, I during the live, you guys who were here, you heard me say he's trying to remove Brennan. I was certain of it. I was absolutely certain of it. But he's still trying to give him the benefit so that we can move forward for the April 1st trial date. He's basically, this is how brilliant this is. Oh my God, it just hit me. It just hit me. Oh, you guys. Oh, this is how brilliant Alessi is. This is how brilliant Alessi is. He is asking, he is asking for Brennan to be removed. I am such a dumbass. How did I miss this? If he asks openly, hey, Judge, remove Brennan, please. Of course, she's going to be like, your motion is noted, but it's denied. But he didn't. He just said, Your Honor, look at all this egregiousness. Look at all of this dishonesty. Look at all of this deceit. And look at the case that allows you to remove him. Do what you will. April 1st is looming. We understand. Finding a new prosecutor between now, there's no way in hell they're going to be ready in not even 5 weeks. It's 4 weeks, basically. They have 4 weeks to prepare this monstrosity of a murder trial. Unless we get a new date and push it to May, June, July, August, whatever. Wow, I'm such an idiot. He asked without asking. That is rare. That is like I said, I am so impressed with his work, Alessi's work. That's incredible. That is absolutely incredible. That is incredible. So we'll see. We'll see what Brennan has to say for himself. We got our OnlyFan going here, so we're still waiting for the judge to come back. I'm very curious to see what... That's actually a good way to put it, ancient... What is it? Ancient Reapers? Ancient Reapers. Ancient Reapers just said, he set a trap. And that's exactly what he did. It's amazing. He outlined everything and then just threw it on the judge and said, do whatever you need to do without saying it. Because if he says it, it actually dilutes his request. But if he just kind of throws it out there and lets her decide, oh, I'm getting shivers. I am getting shivers. Whew. So in less than 5 minutes, hopefully, Auntie Bev will come back from her drink break. And she will let the Commonwealth make their argument. And something tells me they won't be up there more than 30 minutes. Maybe not even more than, somewhere between 15 and 20 minutes. What can they say? It's mostly the defense argument. Because the government made Auntie Bev literally tremble last week. Brennan made Auntie Bev shake with anger and frustration because she thought something was a fact when it was not a fact. When something was a fact when it was not a fact. 10 times over. I mean, that's something. That is something, folks. By the way, I'm curious about the headlines that Alessi was referring to. Let's go to the news. And see last week. Chat, help me out here. What am I looking for? Because I understand there were some headlines that he was referring to, that Alessi was referring to just a few minutes ago. I'm curious, what exactly was he referring to? Yeah, he said it. He spelled it out quietly and implicated Bev, that's for sure. He mentioned the Globe. All right, let's go check it out. Globe, Karen Reed, and this was last week. Judge sheds more light on grave concerns that cut the hearing short. Judge Beverly Canoni has told Reed's lawyers to come ready to address allegations about ARCA witnesses on Tuesday. Yeah.
You are unmuted.
seated. Go to the back in session.
Thank you,
All
Ray.
right. So before I hear from the Commonwealth, Mr. Alessi, I am going to take you up on your offer to ask any questions, and I may have questions for both sides next week. But actually, what I want to do, and you said I could ask questions of other counsel. So while memories are fresh, I just want to assure the accuracy of what was just said. So I'm certainly not going to order counsel to answer my questions. You don't have to, but I am curious. So we're going to start with you, Mr. Yannetti. As an officer of the court, is there anything that you dispute that you just heard from Mr. Alessi? And what I'm particularly concerned about is what you knew or what you didn't know and when.
No, what he said was entirely accurate.
Okay? Mr. Jackson, same questions.
No, and I would simply elucidate with regard to the February 6th sidebar comment. As I look back at I didn't remember making the comment one way or the other. I didn't remember that sidebar.
I did.
Well, I'm sure the court did after it looked at the transcript.
No,
I
no,
did as well
no,
after
no.
I looked at the transcript.
I did long before I looked at that transcript.
The context of that, what was in my brain when I said we don't have anything else to give, which when I reviewed the transcript, was very clearly the federal batch of information, what we've referred to as the federal dump. I did not have in my head at all emails, communications, things of that nature. The
Invoices, payment.
No, nothing. Because the context of what Mr. Brennan was talking about, being frustrated about, were his TUI requests concerning the federal batch of information, and that's when I was making the additional statement. We don't have anything that they don't have concerning the federal information and the background information for the ARCA experts. That was it.
Your Honor, if I could, this is...
No. Hold on. Ms. Little, it was just thrown on you that you're responsible for all discovery, but the same question for you. And again, you don't have to answer, but is there anything that you dispute in the accuracy of what Mr. Alessi told me about what you knew and what you didn't know and when?
No, Your Honor, I would just add that as soon as the court issued the order, I obviously was not in court that day, but as soon as the court issued the order that ARCA reciprocal discovery be provided, I gathered those documents and I provided it. So that was the, I guess, prompt for going to look to see if we could satisfy the 10 things that were outlined by Mr. Brennan.
Okay. So I'm going to hear from the Commonwealth now. It does not look like we'll finish this today because we'll be ending around 4 o'clock. But I will hear you, Mr. Brennan.
Attorney Alessi ended his argument talking about the Sixth Amendment and discounting repeated or repetitive violations. When you consider the conduct in this case, you should consider the history of the case, including repetitive violations, 3.6 violations, protective order violations, and then discovery violations, representation violations. The defense in the first trial attempted and successfully did portray ARCA witnesses as wholly independent, presented themselves as oblivious to the nuances of ARCA, left the impression that there was no compensation, no bias, no collaboration. They postured the information that they gave in advance of the second trial, and I'm going to get to the timing of that, but it ignores entirely withholding this information before the first trial. The defendant presumed innocent has a right to a fair trial, and so do the people of the Commonwealth. It is clear from a reading of the transcripts and the records and the posturing of materials that there was information that showed that ARCA was not wholly independent. Information that was known to the defense, and for whatever reason, perhaps a strategic advantage, was not provided to the Commonwealth, the court, nor the jury. Mr. Attorney Alessi talks about the Gonzalez case. In that case, there was one attorney to cross-examine a witness, which is protocol. Another attorney passed a note, a minor violation of a court procedure. That is like a raindrop in a hurricane. We have a code of ethics and rules to ensure a fair trial for everybody, both sides. Coming in at the last hour and providing information when the avalanches started is not enough. This isn't just about Rule 14. My effort with the ARCA witnesses from the beginning, and I've been clear and consistent, is not to preclude them. It is to get fair discovery that we're entitled to. I did not know
This
for a
guy's
few weeks
so
ago
slimy.
what the defense had known. I did not know that there was conversations and efforts made between them and then inevitably compensation paid. I didn't know that, but I certainly suspected it. I saw Your Honor's questions before voir dire, during voir dire, after voir dire. I remember the conversations sidebar. And those questions were right to the point. And when we were sidebar, I specifically mentioned, I don't know. A voir dire is inconsequential. I don't know what to ask. I can't send them back home to get their records or their emails or any billing. All of that was denounced. All of that was portrayed as baseless. But the court had questions. I had many of the same questions. It is not a surprise that we start to scratch off the tip of the iceberg. It is not complete. There is a murky relationship between the defense and the United States Attorney's Office relative to these ARCA witnesses. And there is a very unclear relationship as we stand here right now between the history of interaction between the defense and these ARCA witnesses. You can see from the emails, while there is some information provided, there are gaps. There are enormous gaps in time. The pause moment on March 24th and then reinitiating on May 5th, where ARCA is actually billing the defense for their works before the voir dire. There had to have been communication between that time that rekindled this relationship. There are two requests that are mentioned in the emails. We didn't get all of those responses. And so we do not have an affidavit from either counsel or any of the counsels. We did not hear a word from any of them. According to Mr. Alisi, what you should do, what the court should do, is go to the federal government and ask
So
questions.
just to be clear, I am not having ex-parte communications with anyone about this case. So I am totally rejecting your request that I do that, Mr. Alisi.
It wasn't a request, Your Honor.
You suggested that I call them.
No, I said if Your Honor wanted to do that. I didn't suggest that Your Honor did.
I'll move on, but the point is, it is
Again,
not
he's
incumbent on
misspeaking.
the court to provide the proof that the defense was given the opportunity to bring in today to clarify the record. Instead, it is the typical 101, blame everybody but themselves. There's no acknowledgement. There's no contrition. And there's no confidence that we are going to get all the materials that we're entitled to. To suggest that ARCA's position did not change, it did change. Their opinions did change by the time they reached trial. It is not that the defense brought out that there was an expert in lighting or crashes happen at night. It is the bias, the relationship that is critical, and that was hidden from the court, the Commonwealth, and the jury. It is the bias and the leaning towards one side that
He's
was
a professional
not disclosed.
gaslighter.
The first trial to disclose it last week or 10 days
Good
ago.
God.
So let me
What a
offer
dangerous
quick
opponent.
history. It is true, when I first spoke to the court, I believed the documents were provided by the federal government, and I did correct that record as soon as I learned before court ended for the day. January 30th, 2025, the United States Attorney's Office responded to one of my TUI requests. They provided billing, including ARCA billing. There was billing for their reconstruction, but there was no billing provided for their preparation, voir dire preparation, travel.
I wonder if
expenses,
Bev was
trial
taking
testimony.
notes when Alessi was
That
speaking,
information
by the
was
way.
provided to both
We
sides
never
on
saw it 'cause
January
the camera was
30th,
not paying.
2025. It seemed at that point that the federal government was being at least a little more responsive, although not directly. No bills other than what the ARCA experts did in putting together their demonstration and their accident reconstruction. February 11th, I filed on behalf of the Commonwealth our motion to exclude the ARCA witnesses. On February 12th, the United States Attorney's Office, it gives us new emails. And those emails were between the defense and the United States Attorney's Office regarding their request to use ARCA witnesses at trial. It's not a surprise that on February 13th, on the heels of these more productive disclosures by the federal government, we then received the disclosures from the defense, which are the emails regarding conversations between Attorney Jackson and Dr. Wolf, and the invoice for billing. Now, I did misspeak. I corrected it. But it is not the source of that information. It is the substance of that information which is critical and relevant. It is that information that should have been known to the court, the Commonwealth, and the jury at the first trial. And it is also that information, when you compare it to the representations that have been made prior to trial by the defense, that has import. And I'm not going to belabor this and go through the comments, most of them again, but it is important before I get to the representations. The court does consider pro hoc vice. We have one licensed attorney in Massachusetts who's carrying 3 pro hoc vice attorneys with the request for a 4th to ride on that same license. There is a responsibility, respectfully, to Attorney Yannetti. He's a fine attorney, an excellent attorney who I admire. But there is a responsibility so that there are not a number of pro hoc vice lawyers doing different things and then later plausible deniability. When we send emails, if I should miss one person on an email, I will receive an email telling me that make sure everybody gets every communication. I've been corrected or redirected many times when we've left somebody out on a communication. Pleadings are signed by all parties. They come through the bar card on that table. And so to try to parse or mince...
The sound is not down. He's just a very soft-spoken lawyer. Everything is on maximum.
Things are done independently, and there's no responsibility for the defense when a representation is made that's inaccurate isn't enough. It doesn't assure that in the future it won't continue. Now, Mr. Alisi said there were rules of the road. This was before his time and mine, but I've read the discovery. There were no rules of the road. There was a protective order. And the protective order was clear that there was no discussion outside of court about the federal materials, and there was nothing in the protective order or direction from the U.S. Attorney's Office that the Commonwealth had any right or privilege to contact any witnesses. Everything is done by the book, by regulation, through TUI requests.
So I have to say, I've never seen the protective order. I received a stack of discovery that the federal authorities were kind enough to get to me in advance of trial last time, because Mr. Jackson had told me he understood that I was operating from a place that I didn't have enough knowledge, essentially, of what was going on. So I received those 3,000 pages plus. I did not receive a protective order. I don't know that I'm entitled to it, but it would be helpful. I don't want to take it if I'm not entitled to it. I don't know what the parameters are.
Your Honor, we have a copy of the protective order. I did ask co-counsel if there was any limitations to it, and I don't have a certain answer. What I'd like to do is...
Call over there, please. All right. If I can have it, I'd like it. It would help guide me through this. If I can't have it, I'll just go with everything I've heard.
May I have a moment to speak to counsel?
Sure.
Thank you, Your Honor.
I will need to call the United States Attorney's Office and get an answer from the court.
All right. I appreciate that. Sorry to interrupt.
And so the portrayal that there was a rules of the road, there was no such rules of the road.
She never apologized to Alessi for interrupting him, but she's apologizing to this guy. Did you all catch that?
Directly, because they understood that that was precluded. And so there was not an opportunity to call or discuss or have conversations, share direct examinations, or have emails with these witnesses. In fact, it's underscored, isn't it, by the emails that we received where Dr. Wolf replies on the 24th saying U.S. Attorney's Office essentially told them to hold off on communications. It doesn't seem like that would be a very clear rule of the road to have independent conversation with these witnesses and then be cautioned that that no longer was viable. And so inevitably, it was the understanding that nobody would be speaking to the witnesses. And I did see in the transcript, in the voir dire, where it was asked, were you available to the Commonwealth? And the witness said yes. I don't know any basis whatsoever for the witness to suggest that there was any invitation to speak to them. And so what we have is we have witnesses that were wholly portrayed as independent. When we look at the testimony, it was represented many times in court, leaving the impression that the defense had no access and no special relationship with the ARCA witnesses. On June 5th, 2024, day 26 of trial.
What date?
Day 26
No,
of
no,
trial.
I know that, but what date?
June 5th,
All right, thank
2024.
you.
Discussing scheduling and voir dire hearings, the defense said, I provided everything we have. I can't make up discovery. I mean, I got a report. And everybody in this group knows why I can't provide additional discovery for ARCA. Everybody knows they've got what I've got. Your Honor asked, I haven't. If you can't, that's fine. So not everybody knows, and I make those decisions. Response, certainly, certainly. You're the one who needs to know, and I thought you knew. The federal authorities will not allow me to interview or ask for additional information from anybody in their world. So I have nothing. I've got a report. He's got the report. That's it. I'm going to start asking questions on the report. That's it. He can cross on the report. So as many times as he says, I don't know what they're going to testify to. Yes, you do, because they're going to testify to the contents of the report. And those are definitely questions I'm going to ask, so I've got clean hands.
All right, so you're reading from a transcript. As you know, there are dozens of transcripts. What's the volume number? What's the volume number and the page number?
Day 26 of trial, page 248 to 250. I will get a volume number for the court.
That's okay.
This seems to directly contradict the theory that Attorney Alisi has been promoting today of the rules of the road. This does not suggest that ARCA is open for business and private discussion and consultation and payment. It says the opposite. It says the opposite. The federal authorities will not allow me to interview or ask for additional information from anybody in their world, so I have nothing. And so this presentation today by Attorney Alisi, suggesting somehow that this was open and notorious, is not backed up by the defense attorneys themselves. The June 10th hearing, we've already been through it. I won't repeat it, but those comments are important. I think what stands out about the prior hearings, and I say that I think that there's a murky relationship that we have not done more than scratch the surface of, is Your Honor may remember that the defense noticed 3 experts from ARCA, including Mr. Klein. And when we get to June 10th, Your Honor is asking, regarding the 3 experts from ARCA, and this is June 10, 2024, trial transcript 28.
Hold on one second, let me grab that.
I believe it's page 12.
Okay.
And you were asking about the 3 experts from ARCA. And you mentioned, notably, I can't tell who does what or what the basis of the opinion is. And when you look at the ARCA report, there's no delineation on which of the 3 experts did what in that report. You can't tell what role each of them played from the report. And so if we only had the report, we wouldn't know which of those experts to call. And so when you continue questioning, you were told well, you said, so I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand. And Mr. Yannetti said, that's essentially it. He gives some detail. As mentioned earlier, we've spoken to them only for the purposes of coordinating their testimony and background. The important point for this particular point is that the defense inevitably calls 2 witnesses, Mr. Wolf and Mr. Rentschler. And when they only call Mr. Wolf and Mr. Rentschler, there must be a reason why. Because you can't tell from the report who did what. They noticed 3 experts. So there must be conversations with somebody explaining the witness's role or why only 2 of those 3 witnesses are important for the defense.
What is he rambling about?
And so it is clear from the absence of information, there are much more communications that are expected to be in existence that have not been provided. On June 18th, 2024, the voir dire hearing. The court asks, well, I thought...
What page? I've got the transcript. What page are you on? Do you know?
No, but I can,
If it's just your notes, that's okay.
I can pull it up, Your Honor.
He's throwing spaghetti on the wall to see if something sticks, says Patrick. You know, that's exactly what it feels like. I'm trying to find his point. Like, where's his point? He's just kind of like all over the place. Alessi was direct. He had a presentation prepared. He had an argument. He had facts to back it up. He had law to back up the facts. This guy...
Page 4, line 11, the court asks, so the understanding of the voir dire is that...
I'm waiting for the
this is
meat.
For the Commonwealth's motion to exclude this testimony. All right, that's what we're here for, the Rule 14 violation. And Mr. Jackson says, is that the same with Dr. Wolf and Dr. Rentschler? And the court says, well, I thought that would help both of you. The Commonwealth has nothing on that, and you say you haven't been able to even talk to them at all about this case.
Welcome to the channel,
And the
Jay
answer
Water.
is that's correct.
Thanks for joining.
Now, refraining from my opinion and characterizations, unlike the defense, I think that the transcript speaks for itself. I'll let it speak for itself. When we continue in the voir dire hearing, page 71,
Okay.
Mark Blaine, Karen Reed is on trial.
line 4, importantly, were you hired by the defense in this case? No, sir. Before this morning, when you walked into court, have you and I ever met face-to-face? No, sir. Now, this illustrates an important point. That is technically true. But what impression is that making to the court and to the Commonwealth? Is that a genuine impression consistent with reality? Line 20, the person to my left, the female to my left sitting here, have you ever seen her before? Nope. Do you know who she is? Yes. And so there is direct and indirect commentary, questions, presentations that reinforce that the defense and ARCA are wholly independent from each other. This is also consistent with their representations regarding payment. There are questions voir dire and at trial about whether or not the witnesses were ever paid. It may be technically true they were not paid at the time they were asked the questions, but if there is an expectation of payment, it is a promise, reward, and inducement.
Thanks for
It
upgrading
can show
membership,
bias.
Aaron.
There's nothing wrong with paying an expert. There's nothing wrong with going over a direct examination with an expert. There is nothing wrong with talking about particular questions with an expert. But when these experts are being portrayed a certain way, that they're independent, that there is no evidence or information about them, then it is not a fair representation. It is not an honest representation. Now, it wasn't until Your Honor asked today that we even knew that the defense paid this bill. When you look at the bill, there's some things that stand out. There's a tax ID number, an invoice date of July 12, 2024. It's addressed to...
Hold on one second, please. Okay.
It's addressed to Attorney Jackson. And the position that the defense takes, Attorney Alisi takes today, is this came out of the blue that they had to pay. Apparently, everybody in the know knew the defense was paying for this expert other than the defense.
No, that was my
ARCA
side. I'm sorry, guys.
experts
I'm just
knew.
frustrated.
Dr. Wolf knew. Dr. Rentschler apparently knew. The federal government knew. When you look at the bill, there are things that stand out that are so notable that you can't go back and try to twist them or change them. Look at the first entry of May 1st, 2024. That is before June 10th. That is before the representations that there was no intention of compensation. Apparently, the witnesses they were going to call expected that they were going to be paid by the defense, or they wouldn't have been keeping track of their time back on May 1st, 2024, participating in a telephone call with Alan Jackson. And so the March 20th email asking for an engagement letter and a retainer, and then the 24th saying we need to take a step back because of the U.S. Attorney's Office.
22nd, I think.
Sorry, 22nd and 24th. There is obviously more communications because the relationship re-engages at least on or before May 1st, 2024, and these witnesses understand that they're going to be paid by the defense. And as I mentioned in the materials we got from the United States Attorney's Office,
Jackie Webb, thanks
on
for joining on
February
as a member as
12th,
well. Welcome to the
there
channel.
is no billing related to prep for voir dire, travel, trial, none. So the only people who were surprised that they were paying the witnesses, apparently, was the defense themselves. And then before that June 10th hearing, where the representations were made, there's a June 9, 2024 phone call. Another participated in telephone call with Alan. And then we see before the voir dire testimony, there is billing to the defense, which is now we know paid by the defense, prepared for voir dire testimony, June 17, 2024. What we don't know is, in the preparation, was there any conversation with the defense? Was there any emails? Were there any documents? Were there any outlines? Was there any discussion about their potential testimony, or is this solely the preparation of Dr. Rentschler on his own? On the same date, 3 hours billed by Dr. Wolf, prepared for testimony and hearing. Now, they felt inclined and comfortable billing the defense for it. Was there any interaction or discussion between the parties? We don't know. This was the time that the court gave the defense an opportunity to bring in their product, their receipts, the emails, to elucidate, illustrate, demonstrate, prove what the relationship was. We don't have anything. We have nothing more than we did last week. On June 18, 2024, a round trip to Norfolk Superior Court by Dr. Rentschler, and also separately for his testimony, 8 hours billed, 12 hours for Dr. Wolf billed to the defense. June 21st, Dr. Rentschler prepares for his trial testimony, bills the defense, 5 hours. Again, we have no idea if that includes in any way correspondence, communication, interaction with the defense. June 21st, Dr. Wolf, the same, prepares for trial, 6 hours. June 23rd, Dr. Wolf travels to Boston for trial, significant delays, and then Dr. Rentschler on the 24th, round trip, Norfolk Superior Court, 11 hours, 6.5 hours respectively, billed to the defense. Now, it's hard to believe these witnesses would put forward money and expenses and travel without some understanding that they were going to get paid. It is hard to believe this company, especially after receiving an email about engagement and retainer, especially after having conversations, collaborating on their potential testimony, it is hard to believe that they would come to Boston, spend their time and their own money to do this, to just simply send a bill later with no expectation of it being paid. In fact, it's a very specific accounting of their time. And when one accounts for their time, it's because they need to have a contemporaneous record so they can get paid for that time. Also billing for wait time and travel, testimony at trial on June 24th, and then there's expenses for June 18th and June 24th. Specific expenses, $1,749, $1,932. So they are keeping very careful track to the bill that they send within 1 month of the defense that gets paid, that Commonwealth and the court never knows about. Talk about correcting a record. And so this $23,925, we find out today, it was paid by the defense. We hear that there was a conversation with the federal government. We have no affidavit, we have no witness, we have no writing, no email, no correspondence, nothing to support or put in context the conversation. Nothing. Nothing. And so when you look at the story on this bill and the timing of it and the details of it, we know that we are getting a fraction of the story. A fraction. It's not enough to blame the court, blame the Commonwealth, blame the U.S. Attorney's Office. There's some accountability. In addition, when you look at the totality of representations made in court, we also, at some point, are going to address the Commonwealth's position of violations of 3.6, separate motion. It's interesting that after the last court hearing, well-known reporter, very reputable reporter, Christine Rex, asks Mr. Jackson about paying the bill. And what I'd suggest, more 3.6 activity. Quote, no, of course not. That was the position last week.
Wait, what?
So what we're left with is we still don't know the relationship between the defense and ARCA. We don't know about the impact it had on the first trial. There has been these multiple representations that ARCA was independent, they had their opinions, and they were exculpatory. ARCA's opinions changed. There were 4 opinions. And if you look at their report, and I'm not going to read it for the sake of the press and the public, we'll have a trial, and we'll vet it at trial. But when you read the report, clearly the representations made about that report were extended at trial. And the question's going to be, why? Why did they improve? Why did the
Particular page you'd like me to look at without.
If you look at the
so
first
hold on.
page,
Yes.
Jackson lied
Never
to a
mind.
reporter?
You don't have to read any of it. You just tell me what paragraph.
First of all, statements to a reporter has no bearing on court proceedings. And secondly, is it the same thing? And even if
I
it
think
is,
it's just the first paragraph
it's
that lays
irrelevant.
out their findings.
Thank you very much.
yeah, they didn't pay for their opinion. Exactly. Is everyone asleep at the wheel here? Is the crux of the issue just the fact that during the trial, the ARCA witnesses said they are not being paid for their time, making them feel disinterested and
I'd actually
Like not a
particularly
defense
note number
witness?
4, and both publicly, repetitively,
Karen
but
wants to
also
rip
at
his head
trial,
off. You can tell.
the parameters of that were extended substantially.
I'm telling you, the ARCA witness is going to be excluded. I say it again. I said it before. She's going to find a way to exclude them.
There is a summary again at the end of that report, substantially says the same thing. If you look at the last page,
Okay.
which is signed by all three of the experts, Mr. Wolf, Mr. Rentschler, and Mr. Klein, says essentially the same thing.
It's 4 o'clock, Bev. What are you going to do?
So we would be oblivious if we stood here and said that the relationship between the defense and the experts, there is no relevance to bias or motive or desire to please, because clearly there's a change, there's an expectation of payment, there's communication, and to suggest that an outline was provided so close to the testimony, therefore it shouldn't have been shared. It isn't just what's in that outline. It's the fact that they have the relationship. Attorney Jackson may have brought out that accidents happen often at night. It's not the point. The point that the ARCA witness is willing to forego that information as a benefit to the defense. That is the heart of what is missing and what is hidden. And so there are a number of instances, 3 of them, in the outline where the ARCA clearly is trying to accommodate the defense. And by representing to the court that there is no relationship, the hands are clean, they have no information, is not only not accurate, it is misleading and unfair. So we know there is more. The question is, will we get it before trial? I have another TUI letter going out this week. I don't know how long it will take to respond to it, and the TUI letter is not going to be thorough and complete. It's just not the way TUI works. And so we are in the same spot. Well, actually, we're in a better spot. We know now about the relationship. We know about the potential bias. We know about the payments, but we don't know the full scope of it. And so we are entitled to that information. We don't know what conversations or communications the defense had with the ARCA experts that the federal government doesn't know about. Over the next few weeks, we're going to attempt to get more information, but we will never have an accurate accounting unless it's compelled. Your Honor has mentioned the sidebar,
Which one?
the most recent one.
Okay.
Exactly, Jay Water.
I am not trying to be overly critical of another attorney. I'm not. You can laugh, but I'm not. It has been my effort to get Rule 14 material. It has been my effort not to exclude ARCA witnesses. It has been my effort to try to achieve fair play.
Yeah, right.
There's been no other way to compel any information other than to file motions in this case. And it is not incumbent on the government to fight for this information. We're entitled to it. We're entitled to it. And at this point, we have no confidence whatsoever, none, that we're going to receive the information that we deserve.
All right. Thank you. Mr. Lessie, very briefly, if you have something.
Yes, thank you, Your Honor. I'll be very brief. And I hope we get an opportunity to have a more fulsome response, but I'm going to be very brief on the key points. Attorney Brennan focused a lot on the invoice. As I said, I work with experts all the time. The experts keep track of time. They had historically been paid by the government. There's another completely rational, more probable explanation. that they had been retained by the government, they were being paid by the government, they maybe at a certain point didn't know who was going to pay their bills because they turned out they were going to provide him testimony. That is a whole different issue, what they expected to be paid and by whom from what the defense expected. So two things can be true. It can be at some point they thought they were going to get paid, but up to that point they were being paid by the government. And in the entries, all that Mr. Brennan went through, particularly the early ones, there is zero evidence before the court on any basis that they expected on those dates of those entries that they were going to be paid by the defense. And it's very important because Attorney Brennan spent most of his time on that invoice. With regard to the comment he made, and this is the problem when we don't have notice, like I provided a notebook so everybody could see it. We don't have some of the things that Mr. Brennan was referring to, but he referred to, of all things, Mr. Jackson's response to a reporter. We're here talking about communications to the court.
The court, exactly.
But to be
It's
clear,
literally what I said
the reporter
earlier.
asked, did you pay for testimony? Did you pay for testimony? Mr. Jackson, of course, said, no, I paid for their time.
Did he say I paid for their time?
Pardon me?
Did he say I paid for their time?
Mr. Jackson?
I said the words, of course not. Did you pay these witnesses for their testimony? And I said, of course not.
Yeah,
if the
it
court
is.
were to ask me that question today, I would respond exactly the same way.
Right, so you just told I paid for their time. That was not said, right?
That was not said, but I'm
right,
saying
that's what
there's
I just
always
asked.
some inference about being what he said, that what was said, but that was his response, that was it. But it was the premise of Attorney Brennan was what Mr. Jackson said to the reporter was different from what you've heard in court today, and it wasn't. It's important to be accurate. The other things that I'm going to go through quickly is it kept stating that there had to be a belief that they were going to be paid by the defense. There is no evidence whatsoever for that because it didn't exist. So now with regard quickly again to the other topics, Attorney Brennan talked about 3 witnesses, right? And he said he was, I believe I took it as clearly inferring 3 ARCA. Your Honor can go back to the transcript. It was Dr. Russell was the 3rd one.
Oh, I thought it was the 3 ARCA people. I will go back to the transcript.
You can go back to the transcript. Earlier on, there was a discussion way early on.
Who is Mr. Klein?
He was a 3rd ARCA expert that was involved for the government, right? And then he stopped, and we didn't retain him for testimony.
Okay.
Let me be clear on what I mean by retain. He didn't testify.
It's been a long day.
I'm trying to answer your question.
I know, and I realize that you just said something that you want to explain. Go ahead and explain what you just said.
So what I'm saying is, in terms of, I'm going to take back the retain. The point is, there were originally 3 ARCA persons on the report that we got from the government, right? Rentschler, Wolf, and Klein. We only went forward with the testimony of Rentschler and Wolf. And that's what I want to come to, Your Honor. The whole emphasis was that the Commonwealth had no notice that we were going to use these experts. Your Honor, the voir dire was the notice. And my point was, I didn't say that there was no bias. What I said was, once you decide you're going to use an expert, right, you're going to be having them testify. Anybody could claim that that testimony is biased. But the point is, Your Honor, that the allegation that somehow mysteriously this 3rd person that was being discussed, and clearly the inference was that we were misrepresenting still about which ARCA witnesses because we weren't talking about the 3rd. The 3rd was Dr. Russell, and you'll see that in the transcript.
Okay, but when I said you expect something, whatever I said, you expect me to believe that you are calling 3 witnesses whom you've never spoken to. When I had that discussion with Ms. Giannetti, that's who I meant.
Thank you for bringing that up, Your Honor. And that was just ARCA. That was nothing to do with Dr. Russell. But here's the important part. Attorney Brennan didn't read the rest of it. You're to believe...
Okay, so where are we? Are we the June 10th, Ms. Giannetti?
Your Honor, June 10th, that's exactly right. That's exactly right, was June 10th. It's important, he stopped...
So it's page 12.
Yes, thank you. So on June 10th, So you're to believe, this is line 19. So I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. Here's the response in its total. That's essentially it. We've spoken to them. So it's not like it wasn't disclosed there was a conversation. It was. We've spoken to them only for the purposes of coordination of their testimony and their background. We've not been able to interview them regarding their findings, which are outlined in detail in the reports. Your Honor, that's 100% true.
You read that earlier.
Right, but Mr. Brennan just mischaracterized it again because that is 100% true. He made it seem like that was an untruthful statement, and I know Your Honor gets it. The other last 2 points, Your Honor. Attorney Brennan talked about that the ARCA experts improved their testimony. My point, Your Honor, was their opinions never changed. Whether they improved is a characterization, but their opinions did not change. And that is very important. And the last point, Your Honor, goes to the discussion that Your Honor was having with the questioning of Ms. Little, Mr. Jackson. I want to be very clear on February 6th, and this is going to be my very last point. When Your Honor asked the questions on February 6th, and Mr. Jackson responded about the discovery, and I said to you that Ms. Little was the one handling the discovery. And I spoke with Ms. Little, and I spoke with Mr. Jackson, and they're going to be completely available for any questions and follow up on this. I asked Ms. Little during the break. She wasn't here for that February 6th. She obviously didn't hear the sidebar. But I said, when you learned of what the Judge Pannoni was asking about, I said, in your head, what was going on and what came to your head? Because I said Mr. Jackson didn't make any knowing misstatement because he had no recollection of any of those March emails. So I asked Ms. Little who would, between the two of them, would, if there was any recollection. So during the break, I asked Ms. Little. I said, Ms. Little, when you heard and got the order, because that's the first she knew of the inquiry, she gets the order, I said, when you got that and you saw that you had to turn over discovery, when you read that, did it come to your mind? Did it come to your mind that there are these March emails? And she said, no. I didn't recall them. I didn't remember their existence. And what I did was I knew we had to turn over discovery. I then went back. I rediscovered those emails, and that's how I had recalled it. That is important, Your Honor, because there has to be a knowing misstatement of fact for 3.3a. So not only did Mr. Jackson not know at the time Mr. Jackson made those statements and recalled those emails, neither did Ms. Little, who was the keeper of all the discovery. And that is my last point, and I will conclude this way, Your Honor. Attorney Brennan conflated Rule 14 issues with the 3.3a1 issues. They are completely separate. I am not here today, Your Honor, to take the position that the defense is in perfect compliance with Rule 14. We're not. But that's a whole different question from whether the attorneys are in compliance with 3.3a. And I would urge Your Honor, as I know you will, to keep those distinctions as we go through the matter, because conflating them is not proper for the analysis. And my last is a citation of law, Your Honor. It was said that Gonzalez involved a very minor issue. Attorney Brennan is correct. There was a minor issue in Gonzalez, but the Supreme Court went through those things that could rise to it. And I'm going to give you another cite, Your Honor, which is United States versus Diazzi, that involved a lot of serious issues with regard to conduct of counsel. They were not pro hoc vice, but it's 807 Fed 2nd 12 First Circuit 1986, where Your Honor can read it as to what were happening. The attorney's conduct was deplorable, and yet the court held that you could not disqualify them because of the Sixth Amendment. And my last point, Your Honor, is when you do a Sixth Amendment analysis, whether or not the attorney at issue is pro hoc vice or not, is not weighty in the determination of balancing the Sixth Amendment. It is not. In the abstract, Your Honor, in civil cases, is it easier to knock out a pro hoc vice? That would be absolutely correct. But when it comes to a criminal case where a defendant and their choice of counsel, that is a much different analysis with the Sixth Amendment. So I will stop there, Your Honor, because you said to be brief. There would be more I would have to say, but those are the highlights for the moment.
Anything, Mr. Brennan?
Very briefly.
Sure.
My arguments to the court have always been focused on Rule 14. The verbal gymnastics that counsel engages in to use words like misrepresentation to distort reality is extraordinary. So let's use the defense words themselves. If you look at docket 505, which was signed in a pleading.
That was filed late, right? On a Saturday or something?
February 16, 2025. This sums it up, really. And this is signed by Attorney Jackson, Attorney Alisi, Attorney Yannetti, certificate of service by Attorney Little.
Is it signed by Ms. Little? It's not, right? It's
Only done the
maybe
certificate of
authored
service.
by, okay.
She did not sign it. It was signed by Attorney Jackson, Alisi, and Yannetti. And this is the defendant Karen Reed's opposition to Commonwealth's motion to exclude employees of ARCA LLC. And here's the representation they make. Not my words, not a misstatement, not a distortion. This is their words. Now comes the defendant Karen Reed, Ms. Reed, and respectfully request that this honorable court deny the Commonwealth's motion to exclude the expert testimony of employees of ARCA LLC, namely Daniel Wolf, PhD, and Andrew Rentschler, PhD. Here's the important part. The Commonwealth's motion to exclude these exculpatory expert witnesses who were not hired or paid for by the defense is not made in good faith and is a desperate and transparent attempt.
That was her side, not me.
Testimony of neutral expert witnesses from reaching the jury in this case. I know Attorney Alisi no longer likes the word retained, but that retained word has import. The reason he said it. Their words, their motion, is no different than the tone of representations made February, last June.
That was her again.
May, and before. Thank you.
All right. So we're back here next week. I believe we're back here Tuesday, Wednesday, and perhaps Friday. Is that accurate?
Your Honor, may I speak to Wednesday, please, the 5th? As this court may know, Mr. Jackson, myself, and Attorney Weinberg are scheduled to appear before the federal court at
What time?
9:30 in the morning.
Okay.
Could we possibly go there and then
Yes.
come here immediately afterwards?
Sure.
Thank you, Your Honor.
Sure. All right, but we'll see you here. Jim, we have these all scheduled at 9?
We do.
Okay.
Tuesday at 9.
All right, so we'll see everybody here Tuesday at 9. We've blocked off the day for Tuesday, Wednesday, and of course I'll let you go to federal court first, and also Friday. All right, so we'll see you next week.
You are muted.
Sure.
Goodbye.
We're going to take a moment to pack up.
Wow. What a nothing burger. What an absolute nothing burger. So, if I didn't get a chance to hear Brennan speak, in open court, and allow me to be the first to say, if you haven't heard it anywhere else first, the dude is a slime bag. I mean, he is so conniving. He is so disingenuous and dishonest and so many other diss words that I can throw out there right now, but I'm not going to for the sake of brevity and because I respect your time. What I will say is that Auntie Bev has her claws sunk so deep into him that she's eating out of the palm of his hand. You can tell the way she's looking at him like her long lost lover. I mean, come on, dude. It's so obvious. She is entirely biased towards the prosecution and Brennan. She was like that with Lally, and now she's like that with Brennan, and she's going to be like that with any prosecutor that comes before her. So what's going to happen now is next Tuesday, maybe she's going to need more testimony. I don't know. She didn't say she's going to make a ruling. She didn't specify. She said we're basically coming back and we're resuming hearings. Tuesday at 9, and then Wednesday whenever the defense team comes back from federal court, and then Friday of next week. So March, basically. We're resuming everything back in March next month, next week. It is atrocious. It is atrocious that we can't get rid of this judge. It's abhorrent that we have to tolerate such corruption, and hopefully the ARCA witnesses stay. If I were to bet money, I would literally put money on the fact that she's going to find a way to strike them. And I'm praying to God that I'm wrong. But I don't think I am, unfortunately, because I know these judges. I know how they work. I've seen them myself in my own practice and in my own experiences. So I am just appalled at this whole like we spent an entire day on nothing productive, and it's all because of Brennan, because Brennan is a professional gaslighter. I saw that today. I finally learned who he is. You all saw that too. He's a professional manipulator. He's a half-truth sayer. He's a deceiver. And, I mean, he's a good prosecutor. That's what prosecutors do. It's a dirty, dirty, dirty job. And he's good at it, unfortunately. And Auntie Bev, like I said, she's eating out of the palm of his hand. And we'll see. Again, I'm not marking anything yet. I'm hoping for the best. I hope that I'm wrong. I hope that I'm just hallucinating, but usually when my gut instinct is pointing in a particular direction, it's usually correct, unfortunately. But we'll see. Again, we'll see. It's not the end of the world. It's not. She hasn't ruled yet. But I have high hopes, for better or for worse, and it's good to be back, folks. It's good to be back. Thank you all, by the way. I've been reading your comments. Thank you all for the compliments on the new studio. As you can see behind me. And somebody asked if those are real books, by the way. Let me take my earpieces out because I'm not going to need them anymore. Yes. These are real books. I even grabbed one of them just to show you. But yeah, this is not a backsplash. This is an actual library with real books. This is not just a green screen or anything like that. This is oh, and yeah, these are real law books as well. This is not just This is not just for show. This is not just for funsies. This is the real deal. I was like, look, if I'm gonna do it, I want to do it right. If I'm gonna do it, I want to do it right. So, we're gonna fix the lighting situation. This is pretty much the last thing that I need to adjust. As you can see, it's a little dark in here in my new studio, but that's why it's a little noisy, grainy. But hopefully, we'll get it nice and crisp. And I'm really excited, you guys. I'm really excited. We're gonna live stream the Karen Reed trial when it resumes, hopefully on April the 1st. And then I'm going to have a meaningful break from the Karen Reed trial as I'm gonna go up to New York for the Diddy trial. At least that's the plan. Barring any unforeseen circumstances or what have you. But I've been in contact with the federal courthouse over there in New York. It's gonna be Johnny Depp all over again. Line sitters, line holders, first come, first serve. Yes, there's an overflow room. There may be several so they can accommodate everyone, but I don't want to go into overflow. I want to see the jury. The whole purpose of me, because everything else I can just, I can read in the newspapers. I want to physically be there. I want to see the jurors' reactions during the trial itself. The Diddy trial is going to be very gross and disgusting. Absolutely. But it's what the people want, I think. I could be wrong. I don't know. You tell me. Some of you, obviously, who have been watching today's stream, I can't even ask, like, would you rather me go to the Karen Reed trial or the Diddy trial? Because you're all going to say Karen Reed. But I may make a poll, like, what preferences. Because, like, the civil case, by the way, against Diddy was dropped. I'm sure you guys have heard by now. Everybody's wondering what prompted that, and most people are saying the witnesses were bought off, which wouldn't surprise me in the least. So anyway, don't forget to subscribe to the channel if you haven't already. Don't forget to like this video. I don't say that enough. I always forget to do that. Zinnia did not get her baby brother yet. We found one. His name is Gillian, and we are waiting for the adoption agency. He's a rescue. He was saved from being, is it euthanized? I think, because I used that word the other day, and Chandler actually corrected me. She was like, it's euthanasia is like when you're putting someone out of their misery, whereas just getting I don't know, whatever. He was going to get, to the kill shelter or whatever, and he got rescued. Him, and he's got two brothers, but we're only taking him. He's not too attached. He's little. He's a baby. He's like 6 months, 7 months, somewhere in that range. And we're very, very excited for Gillian to join the family, and we'll see how Zinnia takes him. Zinnia has been very loving. She loves the new house. She loves the fact that she has a backyard to run around in now. She loves the fact that she has so much space. She has her own space, which is very, very important for animals. I mean, she had space in my previous condo, but I mean, this place is 5 times bigger, 6 times bigger than my old condo. So, so much more room. She's got a whole basement to herself, and she runs around and she loves it. So, yeah, so Zinnia's doing great. Chandler's doing great. Chandler, for some of you who don't know, last month she got accepted into law school. So she is also going to be joining the ranks of my colleagues and myself, and she will be an attorney graduating in, what is it going to be? It's May of 28. May of 28, right? 26, 26. Yeah, May of 28, she's going to be an attorney. Well, she's going to have her JD. She's going to be a law school grad. And then hopefully, if everything goes according to plan, she'll sit for the bar in July, and by October of 28, she's going to be a licensed attorney. So that's going to be interesting. There are going to be 2 attorneys, well, including my stepbrother, 3 attorneys in the family now. She just started her new job about 3 weeks ago. I think she's finishing her first month working for a firm, and yeah, I think things are going pretty good. Things are going pretty good. No real complaints here, but yeah, Chandler has been doing absolutely great. I mean, I've been trying to do everything in my power to make the environment conducive to her well-being and to her health and to her mental stability and all that good stuff. So yeah, I'm gonna keep tabs on like any other headlines that are coming our way. Obviously, I had to do this. The Karen Reed situation is absolutely insane. I really wanted to. Thank you very much, Jay Water. I also need to figure out how to do. Like I said, everything is brand new, as you can tell. The studio, the setup, the camera is brand new. The lighting is new. I'm using I don't use StreamYard anymore. I use OBS. So I need to learn how to highlight. I don't know how to highlight comments. Like I don't have a button anymore. I can't just like, if I press on it, it's from YouTube. Oh my God. The thumbnail case. We won. That's right. Some of you who the words, that's a great question. We won the thumbnail case. It was officially dismissed the day after Christmas last year. So I predicted it. I knew it was going to happen. The only question was when, and it finally happened the day after my grandfather passed away, unfortunately. So it was kind of like, it was a very difficult and complicated week with some bad news, horrific news with my grandfather, and then great news with the thumbnail case victory. I also understand that Doreen and Randy just filed a federal lawsuit where they named Lynette, John, Lisa, Ray Bonecrusher, David Helm. David is the what does he call this channel? He's like the Lego lawyer or something. I don't know. Whatever. He's named in the lawsuit. Lisa Weeks, I think I said. There are like 5 others. And they're suing for like $1.5 million. I love it. I absolutely love it. It's great. I'm gonna cover it. Megan sent me the complaint this morning, but of course I had to do this first. So hopefully I'll get a chance to review it and maybe even make a video on it, because it's long. It's like 57 pages, and that's all the complaint. I mean, there's no exhibits. That's 57 pages of complaint. Not 9 million in total. Oh, I just saw the 1.3. Megan did say 9, but each count 2.135 1. I see 1. And of course my camera. I need to figure out how to, because let me tell you something, and this is extremely annoying. My camera. I use the Canon EOS 7D Mark II. I disabled the automatic like go to sleep mode or whatever, but for some reason I just get this message. I don't know if you guys you probably won't be able to see it. It says press the start stop button to activate movie shooting. Every 30 minutes. Every 30 minutes, it just does this to me. And I don't know what to do. And I don't know what to do. So when I record, maybe... no, Lisa, my volume is fine. It's on your end. Trust me. Might need to be in a different mode. Maybe. I'll figure it out. Like I said, I'm still tweaking things, but so many exciting things are happening. A lot of traction. Change the setting. I know. Trust me. I've tried everything. But right now, I need to fix that and the lighting, and then the studio is going to be absolutely perfect. It's going to be absolutely perfect. I may even do like some lights in the library behind me, which is going to highlight the books. The model number is it's a Canon EOS 7D Mark II. So, yeah, video. Okay, so there it is. These cameras have a video record time limit set to 29.9. I don't know how to change that. I don't know if I can change that. I already spent so much money on this camera. I'd rather not have to get a new one, but we'll figure it out. I'm not too concerned. The fix is to get a camera without a record limit. So that means I would need to get a new camera, huh? Oh boy. Oh boy. Hacked firmware. I saw that. Somebody on the internet talked about it. It's called like Magic Lantern or something. I don't know. I'll have to like literally download it and install it on the camera. It's not official. That's a bootleg. But I may be able to jack it or whatever. I don't want to get a new camera. I'll figure out how to fix it. Okay, folks. Get the Insta360. People are suggesting a new camera. We'll see. I just returning this sucker. I don't know. I might keep it just for photography purposes, if nothing else. I've already invested so much. It's like, what's another $700, right? I guess when you really think about it. But I hope you all enjoyed it. I hope you all learned something. I hope you all are feeling this is what I wanted to do. I wanted to take the legal. Those of you who are familiar with the legal, I wanted to take his concept with his fake background and his fake everything and make it real, right? So he's got his own liberal agenda. I am dubbing myself the conservative legal because I am real. With real books, buddy. No fakery. I hope he gets this message. I don't think he cares. But he's got his liberal fakery. I'm the conservative real deal. That's what I was thinking when I was building the studio. That was my idea when I started building it in my head in November of last year. So anyway, that's it, folks. I hope you all learned something. I hope you all enjoyed it. I hope that we get the right decision, although I'm not counting on it, from Auntie Bev. And the lamp is not blocking me. The lamp is to my left. I'm right here. They got the phone and the lamp. All right, you guys. I could move it back a little. It's just the reason I put the lamp there, by the way, is because it's blocking the microphone. You see I have the mic here. This way, the mic is not as obvious. And it kind of blends in with the scenery. So, I love you guys. Yeah, see? Yeah, oh God, I'm not going to be able to pronounce that, am I? Ichiro Ashiara. I like how the lamp hides your mic. Exactly, that was the whole point of it, right? The lamp is like covering up the microphone. So anyway, all right, you guys, I gotta go. I am starving. I need to eat. I need to work. And I will see you all in the next video.